Hello, and welcome to the November-December 2016 Champion Briefs topic analysis. Today we'll be doing the LD topic. Before we begin, I'd like to introduce myself. My name is Spencer Orlowski. I'm currently the Graduate Assistant Debate Coach at Western Kentucky University, where I coach college Lincoln Douglas debate. I'm really excited and happy that I got to work with Champion Briefs this month, putting together this amazing file. So before we begin, let's talk about what the resolution is. The resolution is resolved: the United States ought to limit qualified immunity for police officers. It's important to note that the Washington Post argued very recently that 768 people have been shot and killed by police in 2016 alone. This statistic on its own gives massive exigence to this topic and highlights the fact that we need to be approaching this topic with a lot of respect and sympathy this month. It's really important that we're not excluding people from rounds and that we're listening to people's perspectives. I would certainly challenge everybody in the community to grow from this topic. So a little bit of a roadmap of what we'll be talking about. First, we'll be going over the definitions and how we can apply those throughout the topic, going into a little bit of background then, and then discussing the main arguments on each side and how I would generally approach it before you get to a tournament. So, like I said, the topic is resolve. The United States ought to limit qualified immunity for police officers. So the first word you run into in the resolution is resolved. In some instances, this claim might be used to justify arguments against performance debate. It might be a negative shell that makes the argument that resolved means that a plan must be passed. But in general, resolved isn't really ever used much in a topicality debate, so we'll move past that one pretty quick. USFG is the next one. You might use T-shells on USFG to avoid questions of parametrics, right? Like you might want a court clog disadvantage, but the affirmative goes through a congressional action, and as a result, you'd want to read the USFG shell to guarantee that link on your disadvantage. You could also be using a USFG shell on the negative as a framework answer to critical or performance debates. If somebody's not engaging with the U.S. federal government, that might be the persuasive way for you to engage on the negative. Rather than like reading your traditional framework arguments, you might just read a T-shell. But other than that, it's not necessarily like one of the big words in the resolution. The next one that you'll run into is the word ought. According to Mizrahi in 2009, in the paper, ought does not imply can. The usage of this word generally expresses a duty or moral obligation. So from the affirmative, using the word ought in the resolution might be relatively strategic for justifying maybe a deontology framework or some kind of ethical framework, right? Whereas from the negative, it might be the converse, right? You might make arguments about how they shouldn't be engaging in policy action, instead should be establishing like value criteria and whatnot, right? But again, still not a very important word in the resolution. Police officer, however, is where we start to get into the substance of the issue. So Merriam-Webster Dictionary defines a police officer as a person whose job it is to enforce laws, investigate crimes, and make arrests, a member of the police, right? One thing you'll notice from this interpretation, however, is it doesn't make the argument that police officers have to necessarily work for the state, right? And so that's kind of interesting because using this interpretation, the affirmative might be able to read PMC type arguments. They might be able to really make arguments about how perhaps the president is somebody who investigates crimes, at least through his executive authority, right? There's a lot of deference you might be able to give the affirmative if your interpretation doesn't include employed by the country, rather, and doesn't include the sort of like actual clandestine portions of the definition. So for a more specific interpretation that could be used to exclude anything that is non-government related, I would suggest the Black's Law Dictionary. Their dictionary in the article, What is a Police Officer, defines it as a person who is an officer of law enforcement team employed by the country, town, municipality, or state. So this is really cool because this allows you to exclude non-governmental actors as the negative. That might be a useful interpretation going through the topic. The next word that I'd like to talk about is limit. So limit can be a noun or a verb depending on the grammatical context of the sentence, right? But in this interpretation, if you look at dictionary.com, you run into like 9 different interpretations of what the word limit means. I would suggest using one of the 3 verb definitions. Particularly, I find the 8th one compelling, to confine or keep within limits, to limit expenditures. But it's important to kind of remember the whole distinction between a noun and verb on this question, because that can be very useful for a standards debate when engaging with limit. If somebody, for example, is defining the noun as the negative, right, the affirmative might have a more persuasive counterinterpretation because it's more grammatically correct in the context of the entire sentence of the resolution, right? So definitely something you'll want to keep in mind really on any topic is making sure that the grammatical context of the card of the interpretation you're using makes sense. So now we'll get into the really important word in the resolution, qualified immunity, right? This is really what we'll be talking about, for the rest of this video and for the rest of the next 2 months, right? So Cornell law defines qualified immunity as a statute which protects government officials from lawsuits alleging that they violated plaintiffs' rights. And it only allows suits where officials have violated a clearly established statutory or constitutional right. Now, I want you to flag that in your memory, right, that sentence. The word clearly established here, I think, is something that could be very interesting for topicality debates, right? Because as this interpretation notes, right, it only allows suits when there is a clearly established previous constitutional right. As a result, affirmatives might claim that by establishing a new right, they have in a vacuum limited qualified immunity, right? And certainly that's up for debate. Some people may argue that's the quintessential example of effects T, right? That by changing one law that it doesn't in a vacuum limit qualified immunity, right? It's just like granting somebody a new right. And then later, when we get down to the cases, that's how that application would apply. Might be considered effects topical by a lot of individuals. And so that's something you'll definitely want to keep in mind with this clearly established portion of the interpretation, is it really leaves that distinction up to debate. But moving on, qualified immunity isn't immunity from having to pay damages, right? It is an immunity from having to go through trial at all, right? Like the trial is intercepted and it just never happens. And so qualified immunity only applies to suits against government officials as individuals, right? Not against suits against the government as a whole. And so that's a really important distinction to keep in mind. This is very much so about the individuals who execute the law rather than the governing body that creates those laws. So the Supreme Court in very recent iterations has strongly signaled that police officers are being given maximum deference when sued under Section 1983 and the Fourth Amendment for using excessive force, right? We have seen almost over and over and over again at both the Supreme Court level and at most district levels that police are not being held accountable. The government is coalescing around itself and really allowing a lot of individuals to get away with things that maybe if there was a court case, they wouldn't be allowed to. So there's a couple of cases I think that or a couple of instances rather, that I think that come to mind to give a little bit of exigence to this topic. Recently, in Supreme Court, a grand jury refused to return an indictment against an officer who was literally on video killing a 19-year-old by the name of Zachary Hammond. And this also follows the exoneration of the police who killed Michael Brown in Ferguson, or Eric Garner in New York City, or Tamir Rice in Cleveland. Like, none of these police officers have been held accountable, and a lot of that is a result of a judicial system that is just coalescing and folding in on itself when being challenged from the outside. So let's talk more specifically about the actual court case that will provide most inherency scenarios. So in March of 2010, a Texas Department of Public Safety trooper by the name of Shadron Mullenix climbed onto an overpass with a rifle, disobeying a direct order from his supervisor, fired 6 shots at a vehicle that police were pursuing. Even though Mullenix wasn't in danger and his supervisor had told him to wait until other officers tried to stop the car, his shots killed Israel Leah Jr., who was driving the car. And he bragged to his supervisor afterwards that he was being super proactive, right? So the family of Leah filed a case against Mullenix for the use of excessive force under the Fourth Amendment as part of their Bill of Rights. The district court heard the case, and the Fifth Circuit Court of Appeals denied immunity to Mullenix on the ground that his conduct violated clearly established law, right? But the court case went up to the Supreme Court, and they intervened, granted Mullenix entitlement to immunity, and continued the presence of dismissing civil rights cases against police brutality around the country. And so that's where we stand right now. On November 9th, 2015, the Supreme Court handed down their decision in Mullenix v. Luna, and they ruled that the police officer was granted qualified immunity, and this applies to high-speed chase situations. So that's where we're at right now. The Supreme Court is very much so giving massive deference to police institutions, and this very much so happens at the expense of rights of individuals all around this country. So now that we've got a sort of background of where we're at as far as the court, we can move into talking about the specific arguments that happen on either side of the case, either side of the resolution. So this resolution is a pretty classic example of a rights versus safety debate. The affirmative is generally going to be making arguments about how rights are being eroded in the status quo, and the government needs to take positive action to help protect those rights. The negative has a couple more options than that, but in general, if they're following like the traditional dichotomy of the topic, they'll be making a lot more arguments based off safety, right? Based off the chilling effects of holding police officers accountable. So let's start with the affirmatives, though. Most affirmatives will generally protect rights in some way. There's a couple of different mechanisms, however, that they could go about doing this. The first one kind of harkens back to what we talked about earlier on the topicality flow, which is you could be clearly establishing a new right. So think about the instance of the moving car example that we talked about from Mullenix, right? A topical affirmative could be one that prevents police, that gives fleeing suspects perhaps the right to not be shot, right? Perhaps we make it illegal for police officers to shoot at moving vehicles. That was certainly one of the advocacies I came across doing my research. That would be establishing a new right that would later make officers be held accountable in court cases. Another mechanism could be establishing body cameras, right? This would make it easier for claims under Section 1983 to be proven, right? Again, kind of like an effects topical mechanism, though, because you're doing something in a vacuum that will later at some point allow for more effective limits on police officers, but it might not necessarily in a vacuum actually do that. And then the other type of mechanism that you could deploy is limiting the access or severity of the immunity that exists, right? Perhaps there's immunity only up to a certain limit. Perhaps certain types of officers don't get immunity, right? These are very direct limits to the qualified immunity doctrine. So we'll first talk about the affirmative that I worked on in the Champion Briefs files that I found particularly compelling and something I would be really honored if you all looked more into. So the advocacy that we established was to render the ADA applicable to arrest situations, right? And so this will be kind of in that first realm of affirmatives where we're establishing a new right. So the ADA, for those of you who aren't familiar, is the American with Disabilities Act, right? And it established lots of different guidelines and paradigms for different situations, right? In the status quo, however, it doesn't apply to police stops, right? There are no federal guidelines that apply to police stops when dealing with people who would qualify under the Americans with Disabilities Act. So Thomas in 16 that we included in the briefs argues that we need to be applying these standards to police stops so that when it comes down to qualified immunity cases, like when we get to the instance where we would be granting qualified immunity, right, there is a new clearly established procedure that they had to have followed, right? And we established two specific advantages coming out of our files. The first one is we talk about SROs, or school resource officers. In a lot of instances, our evidence makes the indication that school resource officers aren't necessarily being trained as thoroughly in mental health interdiction as they have in the past. And so that's leading to a lot of violent confrontations in schools where school resource officers just aren't really prepared to deal with some of the things they might in the field, and so might react with a more of a militarized response rather than that of like a doctor or something like that. And so the same thing also applies outside of schools, right? With CITs. CITs, in case you're unfamiliar, are crisis intervention teams, and the idea here is that there are distinct types of police teams that work with the mentally ill so that they aren't like directly sent to prisons, right? Or they aren't like directly leading to confrontation with police. They sort of teach de-escalation techniques. So the thesis of this affirmative in general is that by making the ADA applicable, it would hold officers and police departments accountable, giving them the incentive to increase training, right? And that's why we get CIT advantages. It gives them the incentive to create these crisis intervention teams. It gives them the incentive to put SROs through new training, right? So that these people aren't being sued, and so that's generally the ADA affirmative, and that's sort of a good model for what affirmatives will look like, right? A lot of affirmatives, I imagine, on this topic are going to be establishing new rights and then claiming benefits off of that. We also include quite a few internal links throughout the Champion Briefs files. We include constitutional stagnation internal links, arguments about how preventing the cases from ever happening means that there's no test case for future legislative or for future constitutional change, rather. Like, if these cases aren't being seen, we're not getting the exigent controversies that might lead to judicial change in the long run. The other arguments that we include internal links for are human rights violations. We give you some generic impact analysis. We've got analysis of how this might lead to justifications for torture, right? How it makes civil rights legislation ineffective because it's not being adequately deployed at a local level when cases are just being thrown out. We also include some framework analysis. We've got some deontology cards. My favorite author on deontology, at least in a sort of safety versus rights debate, is Baer in 11. That's included in our files, and he does a really good job of explaining why making justifications for rights erosion based on minute expectations of safety is essentially dehumanizing and leads to a lot of cyclical violence, right? But this is generally what the affirmative is going to be arguing, whether it's through increased mechanisms with body cameras, whether it's just generally limiting powers by we have another advocacy that limits the immunity from police so that it's no longer representative of the same high government level immunity that the president, for example, achieves. Right now, they all receive relatively similar immunity, and we'd maybe bifurcate those standards, right? But in any instance, most of the affirmatives are going to be attempting to, at some level, limit qualified immunity, because that's the topic. Now, the negative, however, gets to take it from a couple different approaches, right? Now, the most obvious approach, of course, is safety, right? A lot of arguments, especially from police sources, will make arguments about how holding police officers accountable through forcing them to go to court and adhere to Section 1983 violations, right, will make police officers hesitate more, right? It'll increase the cost of policing, and as a result, police may become less responsive to community needs. It makes sense. It's certainly human nature that a police officer is less likely to chase a car down if they think that while chasing a car down, they might be held responsible for any sort of collateral damage that happens. And as a result, maybe whoever that criminal was could get away and continue committing crimes, right? That's the thesis generally of the negative arguments. However, you can also approach it by going increasingly left, right? So I guess that sounds a little abstract, but whenever I approach a topic before we've been to a tournament, before we've seen the actual cases that exist on the topic, I generally like to go as far left and as far right politically as you possibly can, right? Just get as radical as you can so that you can answer an entire plethora of arguments going up to your level, of being radical, right? So in this instance, for our left strat, or rather our more liberal strat, so our negative arguments that try to rather co-opt the rights debate instead of focusing on safety, we've included Afro-pessimism links. We've made arguments about, how reforming the criminal justice system at the end point, rather than looking at the systemic root cause of why racism in the United States happens, leads to a lot of masked oppression and things like that. And so we've included both Afro-pessimism case turns and an entire criticism. We've got some specific case negs that we've included in our file, and this is definitely something I would encourage you to expand on throughout the next 2 months, is answering specific arguments. You'll definitely want some case negs to the ADA affirmative. You'll want some case negs to affirmatives which limit shootings with moving vehicles, right? You'll definitely want a constitutional framework for the negative. But we've included, I think, the most obvious likely case, which is case neg to body cameras, right? Body cameras are a huge thing the past 30 years. And so we definitely included some negative to that. You'll also be interested in this, the term of art called the Flypaper Effect, right? It's this term of art that goes back to judicial activism and makes the argument that when the court tries to artificially impose social doctrine rather on a country, that leads to sort of backlash from the bottom, right? And it's called a flypaper effect, because essentially if you picture a flypaper, flies all getting stuck to it, right? That's kind of a metaphor for legislative and judicial momentum. Generally, when individuals are talking about things like that, for example, there's a book called The Hollow Hope. They'll use the civil rights legislation versus the Brown versus Board of Education and show how little action happened between the 10 years in between those two actions, showing that congressional action was actually the thing that catalyzed long-term change, right? And so we've definitely included some positions which discuss the ineffectiveness of judicial action at generating ground-up social change. We've included things like court clog disadvantages, the docket is overwhelmed at the top, and so you won't be able to actually get things through, right? Kind of your politics disad for this sort of topic. If you recall, we talked about on the topicality flow how you can use a USFG shell to guarantee this link. You'll want to look into things like stare decisis disads based on the rule of law, things about how changing past precedent destabilizes future precedent. But then we've also got the thing that I worked on, the thing I find personally most compelling, which is the Abolish Prisons counterplan. We've also included it as a criticism. With just a productive refusal alternative, and with some rhetoric frameworks too. But this argument is essentially going back to what we were talking about a little bit on the Afro-pessimism debate, which is the idea that legal reformism essentially saps large-scale movements for change, right? Saps momentum from those movements. So the Abolish Prison counterplan operates under the assumption that when you try to make the criminal justice system just a little bit better at a time, all that does is normalize in our lives the existence of that industrial system to begin with, right? And so included in this file, we've got a bunch of evidence comparison, arguments about why our scholarship should be preferable to those that defend the criminal justice complex, right? We've got arguments about media co-option as sort of link analysis for your mutual exclusivity claims, right? we've got some rhetoric frameworks that allow you to make arguments about how the masking of the affirmative should be a voting issue from the negative's perspective, right? But in general, I think the idea of this counterplan is really the important question, right? The idea of just going so far left against your opponent that you co-opt all their ground, right? It seems likely that the affirmative is going to be making arguments about how they protect people's rights. You say the prison-industrial complex is the thing that actually exacerbates rights erosions all around the country, and that abandoning that is probably a more likely and more efficient starting point than, just like one small-scale reform to the criminal justice system. So that's an argument I find pretty interesting on this topic. We've included some arguments about how training police officers might solve, and in that instance, if you're reading like a training counterplan, you could read things like the court clog disadvantage, the stare decisis disadvantage, the Flypaper Effect, right? You can use all of these as sort of like your disadvantage to prove mutual exclusivity. One thing you'll definitely want to prepare for as the negative, especially if you're going to take the first approach we talked about, which is going for the whole safety arguments, you need some util good cards. Like, the affirmative's going to read some deontology, so you're definitely going to want to be prepared on that just to make sure that you're able to leverage your arguments against the affirmative. So that's all I've got for you all today. I really appreciate y'all tuning in and taking a look at this. Champion Briefs, I really want to thank them for giving me this opportunity to talk about this topic. It's certainly a really important topic affecting our nation right now, and I'm really glad that youth of our nation are discussing it and growing. If y'all have any questions, just contact us at the Champion Briefs. Thank you so much. Have a great day.